is a voluntary, irrevocable, and unconditional release of ERISA benefits in a separation agreement, legally binding. Now, those words should give you a clue. But let's talk about the case of Clyburn versus Lincoln National. It's a case out of New Jersey. Ms. Clyburn worked at Brother International and signed a confidential separation agreement as part of her termination. And guess what that release contained? She voluntarily, irrevocably, and unconditionally released Brother and its agents from any and all claims, including the kitchen sink, and more importantly, including those that could be brought under the ERISA statute. Now, in exchange, Brother forgave her a repayment of advance payments that they had made in conjunction with her short-term disability claim. Sounds simple enough, but after signing the agreement and having the repayment obligation forgiven, she changed her mind and she filed a claim for her short-term disability benefits. And obviously, that claim was denied by Lincoln, the plan administrator. Ultimately, this case ends up in court, and Lincoln moves to dismiss the lawsuit, or alternatively says, hey, rule in our favor based on this release. Let's talk about releases. The court acknowledged that as a threshold matter, valid releases can bar an ERISA claim. But first, the court had to determine whether the release language was valid under the totality of the circumstances. So in making that determination, the courts are going to generally consider a number of factors. Number one, what's the clarity and specificity of the release language? Number two, what's the policyholder or plan's beneficiary education and business experience? Number three, what's the amount of time that the individual had to consider the release before being obligated to sign it? Number five, whether the individual knew or should have known their rights upon signing, whether they were encouraged to seek or actually receive the benefit of legal counsel, whether there was an opportunity to negotiate the terms of the agreement, and whether the consideration offered in exchange for the waiver exceeded what the employee was already entitled to by contract or law. So let's apply this to Ms. Clyburn's situation. The court found that Clyburn knowingly entered into the release. It asked whether the release barred her from bringing an ERISA claim against Lincoln. And the court said, yeah, but that wasn't the only challenge. Ms. Clyburn said, look, this release isn't part of the administrative claims file, and you can't rely on it or use it to defend the denial during litigation. Well, the court didn't buy that one and said that was a red herring, explaining that a plan administrator like Lincoln has the authority to interpret both the plan and any related agreement, including the release. So unfortunately, Ms. Clyburn lost her case because of the release. But here's the kicker, and where the court did give her a break. The separation agreement stated that any party breaching the agreement would be liable for attorney's fees. So guess what? Lincoln asked the court to award them attorney's fees, which would have left Ms. Clyburn on the hook for tens of thousands of dollars. Now, the court rejected that request, pointing out that Lincoln wasn't seeking relief for the breach of the contract, but was rather moving to dismiss the ERISA claim, something that wasn't covered by the agreement's fee provision. So here's the lessons. Listen up. Don't sign a release without understanding what you're giving up, or negotiate a carve-out preserving your right to pursue vested ERISA benefits, like short-term disability benefits, long-term disability benefits, health insurance benefits, life insurance benefits, pension benefits. In this release that she signed, it gave up a claim for everything. That could have included any life insurance coverage she had, any pension benefits that she had accrued through her employment with Brother, in addition to giving up her short and long-term disability benefits. And what did she get? Forgiveness of some short-term disability benefits. That was not a wise decision on Ms. Clyburn's case. If your employer is offering you a release to sign in exchange for termination, you must, in my view, have it reviewed by an employment attorney and an ERISA disability attorney to protect yourself. Got it? Let's take a break.
Are you a professional with questions about your individual disability policy? You need the Disability Insurance Claim Survival Guide for Professionals. This book gives you a comprehensive understanding of your disability policy, with tips and to-dos that will assist you in submitting a winning disability application. This is one you don't want to miss. For the next 24 hours, we're giving away free copies of the Disability Insurance Claim Survival Guide for Professionals. Order yours today at disabilityclaimsforprofessionals.com.